Good morning, everyone. I'm Apeksha, assistant professor in Indraprasth Law College, and I will be taking Unit 2. We have done Unit 1 with the Parliament, the beginning, and now in the second unit, the topic is Union Executive. And in this lecture, we'll be doing about President. We also have to deal with the powers, but we'll be doing it later. In this first lecture, it is about basic. So we'll understand from Article 52. Now, firstly, I have mentioned this thing. As we all know, government is divided into three parts, right? But we can say that can be for understanding an executive, legislative, and judiciary. All right. Now, here I have mentioned executive, and our topic of discussion is president. We can subdivide this executive organ of a state, and so it is in president, vice president, prime minister. This prime minister will be doing is also called the real executive. We'll be doing it in the unit 3. So president we have to deal with, and from article 52 to 78 in part 5th of constitution, it deals with the union executive, and 52 talks about the President of India. It is also the shortest article. Also the shortest article in the Indian Constitution, which says about the President of India. Now, the Union Executive, it consists of President, Vice President, Prime Minister, Council of Ministers, and Attorney General of India. And the President is the head of the Indian state. So he is the first citizen of India, and he acts as the symbol of unity, integrity, and solidarity of nation. That is the basic about president. Moving on to Article 52. Now, what does Article 52 says? So the first and foremost part of executive is president. Article 52 states that there shall be a president of India. That president is considered the executive head of the country, and all the executive business of the country is carried out in the name of president. This is what it says. So the union executive, we understood. Now there is a case I have written on Ram Javaya Kapoor versus State of Punjab, which is a very important case. Now what exactly happened in the case was, the government, they invited textbooks and authors from some authors for approval. I'll tell you what exactly, in a brief, what exactly happened in the case. Then when those textbooks they got approved, author all made an agreement, and according to this agreement, the copyright of these books which were invited, the textbooks which were invited by the government, the copyright of these textbooks were vested in the government, and the author only got 5%. Not on the copyright was not given to the author but to the government, and authors only got 5% royalty on the sale of the textbooks. Government took all the publishing, printing, selling rights of these books there. So they took the whole control in their own hands, and what did they give to the author? Only 5% royalty on the sale of textbook. So in this case, the court held that these provisions were ultra vires to the constitutional power. Government, being an executory body, they did not possess the power to enter into an activity of trade without any specific legislation, or without having any specific, this is what court said, without having any specific legislation. Government is an executory body, and they did not possess the power to enter into that activity or trade. Then it also said that There is no restriction on executive power. It is not defined in Indian Constitution. Court held that executives, they cannot be restricted to mere implementation of legislation. So there is a strict separation of power, but no strict separation of functions. This was held in Ramjavaya Kapoor versus State of Punjab. This is altogether to know about President, Article 52, and the executive power. The executive power, which the court itself said that executives, they have a strict separation of power but no strict separation of functions, and that there is no restriction on the executive power. It is not defined in Indian Constitution, right? Moving on to the qualification of president, which is given under Article 58. Qualification of, first and most very normal, he should be a citizen of India, should have completed 35 years of age, should have qualifications which is similar to the member of Lok Sabha, and should be of sound mind, right? So basic thing about the functions, the qualifications. 58 article talks about it. 58 talks about eligibility of a person to become president of India, and the 4 point are the qualifications. Person can also be disqualified for election if he holds the president, if he holds any office of profit under the Union of India or the government of any state or under any local or other authority. So in these 3 cases, the person can be disqualified for the election as a president. Firstly, these 4 are the qualification given under Article 58, and then this is also the point that a person can be disqualified if he is holding any office of profit under the Union of India, government of any state, Union of India, government of any state, and the next point is under any local or other authority subject to the control of government of India, right? So now we have, as I said, they cannot hold any office of profit. Now what does it mean, office of profit? Office of profit, it means that there is a position that brings a person holding it some financial gain. If a person is having some financial gain or any advantage or any benefit, it may be an office or it can be a place of profit where it carries some remuneration, financial advantage or any benefit, right? So that is all about office of profit. He cannot hold, and if he holds, then he will be the person will be disqualified for the post of, for electing as the election as a president. Moving on to conditions of a president office. Conditions of a president office. Now Article 59, the previous article was 58, now this is 59, right? Uh, 59 article. So what does it say? Now it talks about the eligibility. Article 59 talks about conditions of a president's office. The eligibility to become president. It might seem simple, but the conditions of his office are strict. What does Article 59 says? It says the president cannot be a member of either House of Parliament. These are some conditions of a president's office. So basically what is to be understood? That president cannot be a member of either House of Parliament, firstly, or any other house of legislature of state. And if he is a member of any House of Parliament or any legislature of state, he will need to vacate his seat from that house. The day he will be entering into the president office, he will have to vacate his position over there. He cannot be a member there also and a president and joining the office of president. Then these are some conditions of a president office. The third point, president shall not hold any other office of profit as explained. No way of gaining money or holding any other office of profit. Then the president shall be authorized to use of his official residences without rent. These are few points. Then he shall also be authorized to emoluments, allowances and privileges determined by parliament. Perfect. This is quite clear in its own word, plain words. Emoluments and allowances of president cannot be diminished or reduced during his term of office. So the important over here is he shall not hold any other office of profit, and then he cannot be a member of any of the house and still continue to enter into the president office. He will have to vacate it. Moving on to election of a president, which is again extremely important part of this topic. Now Article 60 talks about election of a 60 talks about oath, but election of president is dealt in 54. And the president is elected not directly but by the people, by member of electoral college, which consists of elective member of both the House of Parliament. I'll explain it again, that a president is elected not directly by the people but by members of electoral college. So by members of electoral college he is elected. And what does it consist of? The members of electoral college, what does they consist of? They basically consist the elected member of both the House of Parliament, the elected members of Legislative Assembly of the state, and the elected member of Legislative Assembly of UT, that is Union Territory of Delhi and Puducherry. So three things: elected member of firstly House of Parliament, secondly the elected member of Legislative Assembly of state, and third the elected member of Legislative Assembly of Union Territory of Delhi and Puducherry. And so the nominated member of both House of Parliament, the nominated member of State Legislative Assembly, the members both elected and nominated of State Legislative Council, and the nominated member of Legislative Assembly of Delhi and Puducherry, they do not participate in the election of president. The nominated members, they don't. As the elected members of the Legislative Assembly of UT of Delhi and Puducherry, they consist of the members of electoral college. But when an assembly is dissolved, these members cease to be qualified to vote in presidential election. Now, as it is given in the first point, it deals with provision relating to election of the president. It deals with the provision relating to the election of the president. It says that the president must be elected by the member of an electoral college, and the electoral college should consist of elected member of both House of Parliament and Legislative Assemblies. Now, what is a mode of voting? Again, that's important. It is given under Article 55(3). The mode of voting. What is the mode of voting, right? As per Article 55(3) of Constitution of India, election of president should be held according to the system of proportional representation by means of a single transferable vote. Proportional representation by means of single transferable vote. And the voting at a presidential election, it shall be by secret ballot. So, Constitution, it provides that there shall be uniformity in the scale of representation of different states, as well as parity should be there between the state as a whole and the union in the election of president. Now, how do we achieve this? The uniformity and the parity, how do we achieve this thing? The number of votes which each elected member of legislative assembly of the state, each state, and the parliament is entitled to cast at such election, they are determined by a process. Now, what's the process? That every elected member of the legislative assembly of a state, they shall have as many votes. I'll again explain that every elected member of this legislative assembly of a state I am talking about, they shall have as many votes as there are multiple of 1000 in question, obtained by dividing the population of the state by the total number of elected members of assembly. I have not shown exactly how it is. Okay, I'll show you later. But that is the point. Mode of voting. It has to be done by system of proportional representation by means of single transferable vote. Then every elected member of either house of parliament, they have such number of votes as it can be obtained by dividing the total number of votes. Fine, that's not. Point is, president election is held in accordance with the system of proportional representation and by single transferable vote, by voting by secret ballot. This system, basically this system ensures that successful candidate is returned by absolute majority of votes. Right, so a candidate, in order to be declared elected to the office of president, he must secure a fixed quota of vote. And how do we determine the quota of votes? It is determined by dividing the total number of valid votes which are polled by the number of candidates to be elected, plus and adding 1 to the quotient. So there is a formula. Exactly, we have electoral quota. Formulas are there. But the voting procedure is in this way. And then there is oath. Oath by president is given under 60. Article 60. Yes, it talks about the oath. Who would be giving? Any president which is holding the office of president, delivering function of president. The Chief Justice of India would be in the presence of Chief Justice of India. He will be taking the oath. He'll be made to take the oath. So that's the whole point. And then 71 is dispute regarding the elections. So Article 71, it deals with matter relating to election of president. It states that any dispute arising with respect to election of president will be adjudicated by Supreme Court and his decision will be considered final. So if we see, if the election of a person as a president is declared void, any act done by him in exercise of power of the office of president will not be considered invalid. Parliament can formulate any law regarding the election of president in consonance with the provision of the constitution, of course. And the election of a person as president and vice president, they shall never be called in question on mere grounds that existence of any vacancy for whatever reason among the members of the electoral college electing him. So if there is any dispute regarding the election, it deals with 71. Then term of office of the president, 56. Article 56, it defines the term of office of the president, which is to be 5 years. Now a new president enters the office. Incumbent president shall hold it. So term is of 5 years. The important point over here is this: president resign before expiry of the term by writing it to the president. If he want to resign, he have to write it to the vice president. Then president is removed from his office for violation of constitution by the process of impeachment. Impeachment is given under 61. So this article also state that any resignation made by president to vice president must be communicated to the speaker of Lok Sabha. So it must be communicated to speaker of Lok Sabha also by vice president himself. Now coming to the what is the procedure of impeachment? The president can be removed. What do we mean by impeachment? Removal. Right? President can be removed from office by a process of impeachment for violation of constitution. Though the constitution does not define what does the meaning of this phrase violation of constitution is, but he can be removed by this. Now impeachment charges, they can be initiated by either house of parliament. Now these charges should be signed by 1/4 members of the house, right? The process of impeachment is so that impeachment charges can be initiated by either of the house of parliament. These charges should be signed by 1/4 member of the house that framed the charge, and a 14-day notice should be given to the president before initiating all of that. Now after the impeachment resolution is passed by majority of 2/3 of total membership of that house, 2/3 of the total membership, it is sent to other house which should investigate the charges. So basically president has a right to appear and also to be represented as such investigation. And if the other house also sustains the charges and passes the impeachment resolution by a majority of 2/3 of total membership, then president stands removed from his office. That's the whole process. The impeachment is a quasi-judicial procedure in this parliament. So two things are very important in this which should be noted. Firstly, that nominated member of either house of parliament, they can participate in the impeachment process of president, though they do not participate in this election. Secondly, the elected member of Legislative Assembly of State and UT, Union Territory of Delhi and Puducherry, they do not participate in the impeachment of president, though they participate in his election but not in the impeachment. So these are points to be noted. Don't forget it. Yes, it is written over here. Impeachment is a quasi-judicial procedure in parliament and everything. Moving on to vacancy in president house. So a vacancy in president house, it can occur in the following way: on the expiry of his tenure of 5 years. How can there be a vacancy in president office? If he is expired, firstly, with the correct procedure, after 5 years if he expire, or if he resign, gives it to the vice president, or if he is removed by the process of impeachment given under Article 61. By his death, if he dies, of course, or if he becomes disqualified to hold office, or if his election is declared void. So these are the few vacancy in the president office, the reason as to why, in what ways can it be vacant. Vacancy causes the expiration of the term of the sitting president. Then an election to fill the vacancy, it must be held before expiration of the term. Right. Now, and also one more point, that in case if there is any delay in conducting the election of new president, the outgoing president continues to hold office beyond his term of 5 years until his successor assumes charge. In this situation, vice president does not get the opportunity to act as a president or to discharge the function of president. And if the office falls vacant by resignation, removal, death, or any otherwise, then election to fill the vacancy, it should be held within 6 months from the date of the occurrence of such vacancy. As soon as it gets vacant, within 6 months, it has to be, election to fill the vacancy should be held. And the newly elected president remain in office for a full term of 5 years. And if again the vacancy occurred due to the president's resignation, removal, death, otherwise vice president acts as a president until a new president is elected. So he acts as a president until a new president is elected. And also if the sitting president is unable to discharge his functions due to the absence or any illness, so vice president discharges his functions until that president resumes his office. So president also plays a huge part in the vacancy of the president office. And during, if they are acting like vice president or CGI or senior most judge or supreme court, when they are acting as a president or discharging any of their function, then they enjoy all the power and immunity of president, which is they enjoy every power and immunity which is given to the president. That's it. In the another lecture we'll be doing about power and function of president. Thank you.